Yes.
Lordship, for the applicant in acting number 4. Lordship, I have received a written objection from the petitioner. From there, we begin the short time to file clarification. More like 2 weeks time.
Who is for the applicant?
I am for the applicant.
Okay.
The petitioner is it's a petition to receive.
In the way your lordship can connect the petition, IA 90 of 2025 of will take a week's time to file that.
Here in the writ petition. Okay. You are for respondent in
Yes, 1
1 and 2. In IA, who is in IA?
I am
Respondent. Who is the opposite party here?
the petitioner is appearing to receive.
Lordship,
Yes.
I'm
What-
for the writ petition, my lord.
I think this young Jimman village council is not. I think is not the necessary party. Why?
No, Lordship, I have put
This is why
respondent number.
that what do you call? Who has passed this orders or declaration? Huh?
Lordship, if I may, Lordship, if I may,
Yes.
the Putu Mandan has been acting as the village council also, and the village council also acting as the Putu Mandan. That's what I have brought it before this honorable court through my objection. If you go through the objection, my objection, in the documents of this Putu Mandan itself and the village council itself will show that they are one and the same person. The same person who are in the village council are also there in the Putu Mandan. And Section 6 of the Village Council Act clearly says Putu Mandan will function as a village council.
See, take the analogy. I am a high court judge.
Yes.
While sitting in the court, judicial is something different. I'm also chairman of some this thing.
Lordship, may kindly see.
I'm the chairman of the legal service authority. So in
Lordship,
that,
may kindly see then.
my power will be different.
Lordship, then.
It's
it
not
is
the
by
man,
conduct.
it's the office. It's not the person, it's the
Lordship,
office.
I absolutely understand that, but it is going by their own conduct. Lordship, I file an objection. Kindly see page number 16. It will be everything will be clear. It is because of their own conduct.
Okay. He wants to, file some reply.
Okay. All right, ma'am.
Mr. I Pongana learned counsel for applicant in IA submits that phrase for and is granted a week's time to praise for and granted 2 weeks time to file reply to the objection filed by the opposite party writ petitioners, Mr. and Mr. T.B. Jamir, learned counsel for respondent in WPC 90 of 2025 has also prayed for 2 weeks time to file affidavit in opposition. Mr. Prayer of the learned counsel for the learned counsels accepted. List of accordingly, let this matter be listed after 2 weeks.
Lordship, can let the interim be extended, my lord? There's an interim order. Excommunication. There's an interim order.
Interim order passed earlier shall continue. You just record his name also. Mr. Imti Longjem, learned counsel for the opposite party writ petition is present. Before that, yes.
My lord, I beg to mention item number 12 in hearing columns.
Hearing no adjournment.
My lord, unfortunately, my senior is on pending integrity, so I pray that this matter may come after 2 weeks now.
This was listed last week.
Yes, sir.
On agreement only, we fixed the matter today.
Yes. Unfortunately, yes, go for pending integrity.
Otherwise, I came up just for this case, madam.
You have to pay some cost to Mr. Jigomi. climbing up from Dimapur
Yes.
all the way. It takes 2 hours.
2 hours. A little less than 2 hours.
Hmm.
Because of yesterday's rain, the road condition.
Yeah. We have to compensate. If not cost, something else.
We will.
Lunch, 3 day lunch. Huh?
Sure.
With that condition only.
Okay. I will.
You have lunch and go back. Anyway, Mr.
Geese of the weather.
London Council appearing on behalf of Mr.
Asia.
Ejo, London Council for respondent number. Respondent number 4. Submits that Mr. Joe, London Council, leading council in this matter, London Council, Mr. Joe, has some personal difficulty today. Therefore, fresh for listing of the matter after
2 weeks.
2 weeks. Mr. A.G. London Council for the petitioner and Mr. T.B. Jamil, London Council for respondent number 5. Are present. List of considering that the although this matter was fixed on the consent of London Council for the parties, since Mr. Joe Ejo, London Council, is stated to be under medical problem, let this matter be listed after
23rd, madam.
2023 03/2024.
No more agreements. It's been pending for a long time.
Let this matter be and as agreed to by London Council for the parties, let this matter be listed on 23rd. Don't forget, lunch.
That is about it.
Yes.
Also, I'd like to mention item number 11.
No adjournment.
Also, in fact, here, where during the course of hearing Lordship, respondent number 6 become a necessary party, whereas he has been, the respondent number 6 is included.
Long time back. Long time back.
Long time back.
Yeah.
However, Lordship till such time I'm yet to receive instruction, and I'm waiting for the instruction.
What instruction? Who is respondent number 6?
Since respondent is commandant who becomes a necessary party function.
This is for what? Invalid pension. If rules provide, pay. What's there? Who has to pay?
The state respondents for
So why what commandant? Why commandant?
very clear also.
Why commandant is required?
The commandant is the competent authority who has issued the order also.
Commandant who? What commandant?
Commandant and NAP, 11 battalion NAP.
In the NEP is what?
Nagaland Armed Police.
Armed Police.
Lordship.
Nagaland Armed Police. NAP.
So the competent authority who issued the order Lordship. So
So that's why he was implemented long time back.
Lordship.
If you have not taken the instruction, what can we do?
Oh, Lordship, a week's time Lordship. I'll try to communicate to the commandant. So, Lordship, a week's time I think that.
See, if if the petitioner is entitled under the rules, what he will do? Can he say that no?
Also,
Very difficult. Anyway, last chance, huh?
Lordship.
Heard Mr. Moajamir, London Council for the petitioner. It is submitted by Mr.
Vijmoni.
B.G. Momi, London State Council.
Lordship.
Senior government board.
Lordship.
Senior government.
No, Junior government.
London State Council submits that. Although the respondent number 6, submits that respondent number 6 has nearly been implemented. No instruction. Instruction is yet to be received from the said respondent number 6. Therefore, praise for listing of the matter after a week. Mr. the Joshua Seki Learned Council for Respondent 5 is present. Next para. Considering that the respondent number 6, Commandant, NAP, appears to have issued the impugn order. Impugn order. No, appears to be a necessary the authority to answer the grievance raised by
Your Lordship, more particularly, if you go by Rule 39(6) of the CCS pension rules, Lordship, that is 45 years of service. Rule 38 is about physical infirmity or bodily injury or even death. Lordship, that is to be clarified by the respondent number 6 as to whether.
That's why
Yes,
I'm
sir.
saying, the prayer for Learned State Council is accepted, accordingly, list the matter after a week. Just read on which date the State Council shall invariably place the instruction.
Thank you, Sir Lordship.
Yes.
Number 7.
Hmm.
Allows the credit value to from the public level.
Okay. You have taken the consent. Yes. No objection. On the prayer, Mr. MS,
Each of the state.
Learned State Council. Further, 2 weeks time.
3 weeks.
3 weeks time is granted to file affidavit in opposition. Next para, MS so and so is present. For petitioner is present.
It's on behalf of my colleagues, Lordship. Then 3 weeks time to public.
Same order.
Lordship.
You just record so and so. Item 8.
Yes, Lordship, item 8.
You record his name for petitioner is present.
Lordship, I did not get this one. Here I did receive instructions, so
Huh?
here I did receive instructions, so 3 weeks time to public.
You have not received.
Lordship.
Yes.
Yes, okay, for
Mr. Joshua Seki, Learned Council for the petitioner. Next para, on the prayer of MS Venture. 2 weeks, 3 weeks,
3 weeks, Lordship.
3 weeks. Same one. To file affidavit in opposition.
Lordship,
Lordship, also like to mention and the word trade. Lordship, I'll be very glad in the process of the Lordship. At number 3.
Yes. Any objection?
She seemed that she'll file her affidavit today.
Lordship.
After a list, we'll list it after a week
Lordship,
or 2 weeks.
after a week,
After a week.
as admission.
Heard MS Judge Zimomi Learned Council for the petitioner. Next para, MS Swenso Learned State Council submitted. An affidavit in opposition would be filed today, filed during the course of the day. Therefore, fresh for listing of the matter after a week. Praise the Lord. List this matter after a week.
Reply if any, Lordship, since I haven't received.
Yeah, it's up to you. We cannot stop you.
Lordship. Also, the respondent number 5 has already received the notice on 37/25, but no appearance.
It's okay. If he has received, no issue.
Yes, Lordship.
Thank you.
Yes, Lordship, Lordship, I'd like to mention item number 9.
Hmm.
If it's going to be granted to find the affidavit.
Your Lordship, in this case, my interim prayer is pending. Unless there is a stay allowed, the state normally takes their time, so I'm asking for.
What is the interim prayer?
Your Lordship, to withhold any appointment to the vacancy as on the date of filing is 13, and anticipated vacancy this year is 21, so there are to be 34 vacancies. And Your Lordship has been with the state also, my Lord is aware, appointments, they keep on going. And unless there is a stay, normally the state takes their time, so I'm asking for.
What is the interim prayer?
Your Lordship, to withhold any appointment to the vacancy as on the date of filing is 13, and anticipated vacancy this year is 21, so there are to be 34 vacancies. And Your Lordship has been with the state also, my Lord is aware, appointments, they keep on going. And that is without fulfilling the conditions laid down in the law itself, the act.
Is there any order that your interim prayer will be considered
No, it's not.
today?
Lordship, it is to be considered on the next date.
No, Lordship, otherwise I said the petitioner has not the case. She cannot compel the state to keep reserve one post for her. She is claiming
No, I'm not saying that it has
she's
to be reserved for me.
under the
But if
disability.
regular
Act.
appointments happen,
So
I will.
it's a 25 vacancy, only one post will be available, Your Lordship. One post will be
See-
available only if there is 25 vacancy. So Lordship, can you do 3 weeks time, so that within that period, I'll try to.
3 weeks or 2 weeks?
3 weeks, Your Lordship.
See, he on the basis on the basis of the mandate of the law.
Yes, the of the law has complied with that. Till now, 4 persons have been appointed on disability, Your Lordship.
Only 2 months.
No.
Out of 505.
Lordship,
If you-
everything I will bring on
Then
record.
2 weeks. 2 weeks.
Lordship, make it for 3 weeks, Your Lordship, make it 3 weeks. 3 weeks within that period.
And the appointment process is in the works.
No, Lordship, because there is no vacancy, Your Lordship.
Oh, there is no.
The 13
No, I'm
vacancies
asking
are
whether
already filled up.
the selection process is in the works. I mean, is under process or something like that.
No. There is no.
There is no selection process.
Not because the other persons who were appointed were selected through a selection process, Your Lordship.
Which selection process, my lord? No selection process has been had, and then starting from 28th of August 2025, that is the date of reply of RTI, till the date of filing, there were 13 vacancies, my lord. So
So
if there is no vacancy, then it has already been filled out through an unknown process, my lord.
that's why if there is no selection process, when the question of we're asking them not to fill up.
No, that is why, my lord. Now my learned friend is saying that there is no vacancy. Whereas the RTI reply shows that there should be 13 vacancies, my
If
lord.
the selection had there been a selection process in the works, we would have stayed.
I would
At least not to fill up at least one. But if there's no selection process, we cannot have a
But now, my lord, if
blanket.
they take the submission
Cannot
of
pass
my learned friend.
we cannot pass a blanket order.
Now, my lord, my learned friend is saying that there is no vacancy, whereas their own document, state's document say that there should be 13 vacancies, my lord.
Okay.
Now,
So therefore, since there is no selection as such, as on today, therefore we'll grant them 3 weeks.
as far as granting time, my lord, I have no issue, but when there is some kind of restraint, then my lord, the method.
No,
Yes,
had there been some selection process in the works, we could have understood, we could have asked them not to fill up at least one post. But there's no selection process.
Then my lord,
Even it's not in the offing.
some kind of mechanism has to be there, my lord, to stop.
Obviously, we'll
consider.
consider everything. We'll consider all that. We understand that mandates of the law has to be followed. You have to go by the law. Now, so far the interim order is concerned, prayer is concerned, we cannot pass the blanket order. Because there is no selection process in the offing, or it's not in the works. All right. Okay. Heard Mr. Jeswasaki, learned counsel for the petitioner. MS Sokri. A Sokri. Yes, sorry, V Sokri. It's been a long time. V Sokri, learned additional advocate general. Press warden is granted 3 weeks time to file affidavit. List after 3 weeks. That's what.
One motion, item number 1.
May it please, my lord,
May it please, Your Lordship.
Yes.
My name would be appearing through BC.
Yes. Yes, madam.
may it please, my lord, the present matter is therefore a motion. If I'm audible, my lord.
Yes.
Yes, my lord, what has happened in this matter is, on the 31st of July 25, an inspection was conducted in the business premises of the petitioner. Thereafter, on 1st of August and subsequently on 11th of February, summons were issued under Section 70 of the GST Act 2017, my lord. Initially, the petitioner could not appear personally. However, he had sent email communications and there were back and forth communications between both the parties going on. Thereafter, my lord, on 2nd of February 2025, 5th of February, and 9th of February 2025, all the details pertaining to financial year 2021, 2022, 23, and 24 have been submitted to the respondent authorities, my lord, for the purpose of GST search, my lord, in terms of the summons issued. My lord, well, now what has happened is they've issued a impugned order dated 27th of February 2026 for
Where is it?
provisional attachment.
Where it is?
Lord, annexure 5, my lord, page 28. They've issued this impugned order for provisional attachment of property of the petitioner, my lord, which is the bank account. My lord, now from the summons till the stage of the summons till today, my lord, communications were going on and all the documents that have been requested by the respondent authorities have been duly submitted, my lord, and there has been no determination of tax till now. So therefore, my lord, this provisional attachment, we are praying for a stay for this provisional attachment of property, my lord, under Section 83, impugned order.
See, today if we stay,
Yes,
it
my
will, it will amount to granting full relief. So we'll just issue notice, right?
My lord.
Suppose if we stay this matter
My
and
lord.
clear, that will amount to granting full relief, which is not permissible under the law, right? We'll
Yes,
issue the short notice. I mean, 3 weeks. Which appeared for the respondent. Huh?
They were kind of mentioning on now accepting notice on the respondent one.
Don't make a mention. At least motion, so you should not make a mention. All right. Heard Mr. MS.
S. Sharma Hazarika, my lord.
S. Sharma Hazarika, learned counsel for the petitioner. Challenge made in this writ petition is to the communication dated 27/02/2026, passed by the issued by the Additional Director General DGGI, Siliguri Zonal Unit of Directorate General of GST Intelligence to the branch manager, Punjab and Sindh Bank, Dimapur branch, Nagaland, whereby the bank account being account number 303491100002547 of the petitioner, page 28, is provisionally attached under Section 83 of what?
Of the GST Act, my lord.
GST Act of 2017.
Yes, my lord.
2017. List of next para. It is the contention of the petitioner that proceedings has been initiated under section.
Lordship, only summons have been issued under Section 70 till now.
No, initiated proceedings has been initiated under Section 70 of the Central Goods and Services Act 2017 by issuing summons to the petitioner, to which the petitioner is responding and cooperating with the authority. List of assume that no determination of the tax Huh? There's no,
Yes, no determination of tax till
there
now.
is no, isn't that determination of the tax against the petitioner is yet to be yet to be met. Therefore, the provisional attachment of the property of the petitioner being account number so and so is illegal, which resulted in depriving the petitioner issue notice returnable by 4 weeks, 3 weeks. We'll make it 3 weeks. 3 weeks. You are appearing for Mr. So-and-so, Learned Counsel, appearing on behalf of Yangarbati Learned CGC, enters acceptance and enters appearance and accept notice on behalf of respondent number 1. No, as Mr. So-and-so, enters appearance so-and-so, and accept notice on behalf of. Come on. The formal issuance of notice to respondent number is dispensed with. However, extra copies be furnished to the Learned Counsel for the respondent number 1. The others you have to take steps.
Yes, ma'am.
The petitioner, Learned Counsel for the petitioners to take steps for service of notice upon respondent 2, 3, 4, 5, and 6 by speed post as well as usual process. Within 2 days, 2 days you take time. I mean steps, right? Right?
Yes, my lord.
List after 3 weeks.
Oblige me.
Item number 2.
Yes.
And matter is a instrument case. The petitioner's father was serving as DB, that is the Wajir man, under the office of the Deputy Commissioner to Insam expired in 2005. At that time, the petitioner was 12 years of age. The petitioner was left orphan because the mother had also expired prior to the family. Now in 2007, the pension.
Let us see, we'll issue notice. Heard Mr. Ponganor, Tongpok Ponganor, Learned Counsel for Deputation. Next para. This is the petitioner. No, this petition has been filed seeking a direction to the respondent authorities to settle settle and release the family pension,
Yes.
Family pension benefits, including the gratuity also.
Yes, gratuity and GPF.
Gratuity and GPF in respect of she's lady
Yes.
petitioner in respect of her father,
Yes.
late Y. Yelukyu, XDB, Office of the Deputy Commissioner. No, XDB, no, who was working as what is Doboshi in the office of the Deputy Commissioner, Twensen District,
Yes.
and died on when?
11/9/2000.
11/9/2005.
Yes.
List of. Next para. It is the case of the petitioner that despite submission of all the required documents, the family pension, including the employment plans including gratuity and what gratuity and
TDI.
GPM is yet to be released. Mr. That's all. Issue notice returnable by 4 weeks.
Yes,
All of you are appearing. All the respondents are represented. Both of you are.
Yes, and for respondent number 1 to 3 state respondents.
Then you are for 4. Since
On behalf of my senior.
Mr.
Yeah.
K. Angami, London State Council, and MS London Council enters appearance on behalf of all the respondents, no formal notice need be served. However, extra copies be furnished to the Land Council for the respondents. List after 4 weeks.
For admission, item number 5 and 6.
Well, in item 5, I've received affidavit in Nakum. So I will be.
No, you have seen the last order.
Malo,
You have seen the last order. Last week I passed a small order, echoing my view, prime facie view.
malo.
This is listed for you for your appearance today.
And
See, since contempt is there, you pursue the contempt, right? Please pursue the contempt
Malo, I'm
because you are raising the same grievance which this court has already given to you.
1 week.
Yes. It has been given to you. Now they have not been compliant. So accordingly, rightly so, you have filed a contempt petition which is pending. You pursue that. So it depends on the outcome of the contempt.
Malo, I
Said it.
understand. Yes.
Outcome of the contempt.
Malo.
Thereafter, you will not be rendered remediless. You will not be rendered remediless. Suppose in the contempt, if they say that we have complied, better ends there.
There is,
If they pass any orders
yes,
against you, you can always liberty to challenge that order. Therefore, at this present, this parallel proceedings of the writ proceedings, right, and the contempt cannot go on because the grievance this court wrongly or rightly has already granted to you.
Malo.
It is the ball is in the court of the government authority, which they have not acted. Accordingly, you have rightly filed a contempt petition.
Malo.
So will you allow you to will not pass any saying that the order is not maintainable because it may have
Keep it over.
it may have a bearing, it may have an effect on you in future, right?
Malo.
Therefore, I suggest you, what up to you, to withdraw this writ petition with a liberty to file fresh. In the meantime, you don't file a petition again, we'll grant you a liberty, but you pursue this contempt petition, not the writ petition.
Malo, I understand you, Lordship.
This is for your benefit.
Yes.
Otherwise, if I dismiss on your this may have a bearing on you. It may affect you in future. So you pursue the contempt,
Malo.
right? If they don't do it,
Malo.
and if the contempt petition is disposed of, you will be always given a liberty.
Malo, in that manner, your Lordship, yes.
Yeah, you withdraw this writ petition.
Malo.
Huh.
Liberty.
But don't immediately file just because
No.
you pursue it's for benefit of you on their
I
side.
understood. Yes.
You pursue the contempt
Malo.
first, huh?
Malo.
Okay. Mr. I
Inti Longja.
Imti Longcha, the counsel for the petitioner, submits that he may be allowed to withdraw the writ petition, withdraw the writ petition with the liberty to file afresh if occasion arises. Huh? Please stop. Mr.
That is only my lord.
Learned counsel for the CJC.
Yes, ma'am.
Learned CJC is present. Accordingly,
That is only my lord.
Jed and Moli. He knows. You know, yeah, Jed and Moli. And Learned CJC is present. Accordingly, writ petition stands closed on withdrawal with a liberty as prayed for. That is one thing. Then item 6, contempt petition. Heard Mr. So-and-so, I, Imti Longsir, then counsel for the petitioner. Any notice has been served? Notice has been...
Through usual process, so maybe about
Press steps. Notice issued upon respondent. No, you have filed by a place. No, it has been sent on 9th only. We'll say award service report.
This is the second.
No, so because this is on the direction of this court only, this matter was listed.
Malo.
Therefore, we'll say that let this matter be listed after a week.
Malo.
List the matter after a week. You take instruction, if possible. Of course, we cannot force you.
Yes,
We may just request it.
Respondent by law.
You file it.
I have to file Bakalanama.
Yes, you file it. You find it out. You take.
My clients, I cannot.
That's what I'm saying. You take instruction, saying that its contempt petition has been filed because you are a learned standing counsel. Your officer may be, unless you are engaged, you are not
Yes, ma'am.
officially cannot appear. I'm not official legally, but then you bring just say it a contempt proceedings. We should not take it lightly. All right. We're not saying anything. We're not recording anything today.
Yes, ma'am.
It should be listed after 1 week. In the meantime, you try to obtain instruction. Try to find out what's happening. All right. And advise accordingly.
Marks about.
For hearing, item number 13 and 14.
Yes.
Worship, I have some difficulty today.
No adjournment.
I have to go to the doctor once. Otherwise, I have some do content better. First I can. Otherwise, I have to go to the doctor. Some problem. Worship,
And what is the other case? Tosile. Tosile is what?
Worship, in this case, worship, the petitioners of the private respondent, worship, they were participated in the selection process. Worship, the private respondent, she.
No, I'm asking, just wait. We'll come to that. We'll hear you. What about this item, this WPC 176?
Worship, the petition number 176, it was dismissed earlier by a single page.
Ha,
I filed an appeal.
ha,
In the appeal, the complaint for the restored my writ petition,
ha,
and it was corrected to be listed along with the present writ petition.
ha. So this is 176 is what, about what?
Worship, here is connected.
Ha,
Worship, it's happened like this. Worship, in 176, I'm challenging the recommendation of the private respondent on the ground that she's not an indigenous independent of law.
yes.
While dismissing my writ petition,
Hmm.
the learned single judge has directed the state respondent to conduct an inquiry.
Ha,
Inquiry was conducted.
ha,
And during the inquiry, the private respondent, the petitioner represented 296. She was given an opportunity to submit the documents in terms of the 1977 notification. Since the state government passed and issued a notification in the year 1977, laying down 3 criteria. In order to qualify as an indigenous inhabitant of Nagaland, one has to fulfill the 3 conditions. During the inquiry, it is admitted fact by the private respondent that she cannot produce the documents which is prescribed under the 1977 notification. That is already admitted.
Now, what I'm trying to understand is this Kutoli Seki.
Totally.
You are for him.
No. I'm against her.
Who is for
I'm for.
Kutoli Seki?
I'm for.
You come this side. Why you are sitting there? You are this Tosile is you.
Seriously,
So you are respondent here,
I'm also responding.
and she is you are responding and
I'm the respondent in WPC 176.
this has been restored. Writ petition has been restored. I mean, the division bench has directed to restore the writ petition,
Yes.
right? So now your case is that
Their sole case is now this. During the inquiry, she submitted a representation saying that she cannot produce the documents as prescribed under 1977. Now there are already reliances on the judgment passed by a middle page of this in the year 1990. Whether the judgment is relevant with her case one, only that has to be relevant. That is the only issue.
no, her indigenous
Inhabitants will cancel.
saying that she doesn't qualify to be
To be an
indigenous inhabitants.
as per the 1977.
And you are saying that you are supporting that.
No, I'm against that.
You are supporting that she is not an
Yes.
indigenous inhabitant. Therefore, you have filed this 176.
No. Worship is like this.
Who has filed 176?
Worship me.
Saying what? What is your case here?
I'm challenging her recommendation.
Yes, saying that she cannot be she could not have been recommended because she is not an Indian. That's why I'm saying.
Yes.
So you are supporting the action of the ultimate action state. Initially, you were against, right? Right. Now, the state has said that she doesn't qualify to be indigenous inhabitants. Therefore, your writ petition, what remains here? When you say
The BBC 177, it will be subject to the outcome of this WBC 296.
that's what I'm saying.
If she's not qualified, since I made select this serial number 2. No,
That's what I'm saying. It depends on this
296.
296.
Exactly.
If we allow, all right,
Nothing remains.
nothing remains for me. If we dismiss, also nothing remains.
No,
Suppose if we dismiss 296,
296.
which the impugned order, where the impugned order says that C is not qualified to be indigenous inhabitants. That is what you want. If it is dismissed, nothing remains. Right? And if it is allowed, all right. If it allowed also, you cannot challenge the repetition.
No, Rashid, the issue is this. In the select list, Rashid, the petitioner.
Suppose before we entered into the marriage, just see, you are saying that she is not a indigenous inhabitant, right? Then you filed it at 176, right? Now, as per the direction of this court, inquiry is conducted, and the authority said, no, she is not indigenous. She is not qualified to be indigenous inhabitants, right? Which is in your favor, right?
Rashid, the prayer in my read petition is to cancel the indigenous inhabitant and to consider my case in terms of the select list.
Because you are there, you are a respondent here.
I'm there.
Right. So it depends on this case. If it is allowed, you may file an appeal. We cannot hear it again if we allow the writ petition. Right. If it is dismissed, your grievance is, redressed.
Rashid, by prayer in the BBC number 176. If this 296 is dismissed, in that case, since I'm at serial number 2 in the select list, Rashid, my case can be cancelled.
Serial number 2.
Serial number.
So we'll hear this only.
296 will be.
It depends on. Suppose if we dismiss the writ petition, so this in view of the pendency of this 176, we may think of passing that order, right? Otherwise, nothing. You have nothing now. You have nothing to say. You may argue in this here. You may argue here. Yes. What is the
other day? I applied for that copy of that 176 from the registry. I'm yet to receive.
What 176?
No,
I said that you have seen it, you have heard it, nothing.
Yes.
Nothing. We will just keep it like it. Depends on this case. Yes, Argo.
And my humble submission before working, if this marriage tomorrow after
No, not tomorrow.
Because I'm disabled today.
No. Your order, you have filed an affidavit. Yes. Affidavit on behalf of respondent 1 to 6. Yes. You go through the affidavit. That's all.
Please, Your Lordship.
Yes.
Also, there is WPC 296.
You come this side.
Lordship.
For a time being, you go that side. Imti, are you seriously going to hospital?
I just want to question, but
You go in the afternoon.
doctor is here. What do
You go in the afternoon, we'll see. Are you serious?
Yeah, what?
Yourself?
Yes,
Body ache?
yes.
I mean,
We can try tomorrow.
My uncle somebody tomorrow.
No,
after
tomorrow.
DD.
Tomorrow it's DB. It's
After
not,
DD,
it's not possible.
it's possible.
Today we have no work
Of course.
except this matter. So I would like to hear into this. You wait for some time, you go in the afternoon, tell the doctor.
But that 176 also.
Hopefully, I wish you're not that serious.
Probably.
Huh?
I believe it probably is.
Can last for at least 2
I am
hours.
a very healthy person.
Can you last for 2 hours? Can you last for 2 hours?
No.
Can
If
you?
doctor is available here, to take some medication on.
Then
But 176, I have no documents at all.
no, 160 is done. Doesn't require. He has agreed. See, His grammar is saying that except for recommendation, saying that she is not an indigenous the inhabitants. You have said yes, he is not. She is not.
Yes.
Better and say. Yes.
In this petition,
Huh.
primarily I'm challenging the impugn orders
Yes.
on two grounds.
Yes. Let's see the impugn order. What it is?
You find this in Annexure 7, page 27.
27.
Oh, sorry. Apologies for you find this in page 74, Annexure 15.
Yes.
Now,
Hmm.
in first notification, in pursuant to the Home Department letter number so and so, dated 14 November 2022, and Commissioner Nagaland letter so and so, number so and so, dated 11 April 2023, regarding verification of indigenous inhabitant court. The matter regarding verification of indigenous inhabitants certificate in respect of Srimati Putoli Shetty, daughter of late Pinakar, also known as Pinakar, alias Kumar, has been examined by AR branch, and it is conveyed that based on the verification report submitted by the ADC Pugaboto in view of the PNR notification AR 876 dated 28/4/1997, Srimati Kutoli does not qualify to be indigenous inhabitant of Nagaland, unquote. Consequently, the indigenous inhabitant certificate registered number 762 dated 14/6/2000 issued by the stands cancelled. Lordship, that is the main notification that I'm impugning.
Yeah.
Lordship, may I take your Lordship to the inception of this very case, because
Yes.
this is the second notification.
Yes, yes. Where is the inquiry report? The verification report by the ADC.
You will find this in Annexure 18, page 77. Sorry. Yes.
Verification is Indian name request of Sri Putolu Sekio. Page 77.
Page 77.
Right. Yes.
However, Lordship, may I start from the beginning?
Just wait. But you yourself said that you were despite granting of time to produce documents. You said that the documents as prescribed in government so and so cannot be produced. In your letter, you have said so.
Lordship, I have made two complaints after the inquiry has been conducted. Firstly, because of the
Are you challenging the inquiry?
I'm challenging the inquiries for what?
The inquiry is based on the verification is based in terms of the order of this court,
Yes, Lordship.
pursuant to the order of this court.
Lordship. However, there is a violation of the binding direction in this, so far as the division bench, earlier division bench in Nila Duo versus State of Nagaland. The earlier judgment has specifically directed that this judgment has to be taken into account, consideration has to be made in terms of this judgment. However, no consideration has been made on account of this judgment. Because Lordship, besides the 1977
You start from beginning now.
Lordship. Lordship, we'll find in page 60. Page 60, 62, and 63. Initially, ST and indigenous certificate were issued in my favor after I applied for ST and indigenous. And then by annexure 1, Lordship will find that since I've been issued ST and indigenous certificate, I applied for a post of grade 4 post when advertisement was made. Lordship will find the advertisement in annexure 1. As your Lordship got it. Annexure 1, page 18.
Advertisement. Page 19.
Page 18.
Yes, advertisement. For post of?
Yes, for the purpose of recruitment of grade 4 post under ABC Pugabuto. Lordship will find serial number 14.
Grade 4.
Grade 4 post.
Yes.
At serial number 14, this is relevant to our case.
Go ahead, please.
Lordship, and then interview has been conducted.
Okay. No dispute.
Lordship.
Then
yes, I came out in.
What is the selection? Interview in marks of.
But this is not eligible therefore the type copies in page 21.
So this
now
is
petitioner came out in merit list number 1.
Kotilo Saki. Yeah.
Yes.
Yes. Then.
So confirmed this.
And it was you were appointed.
I was appointed.
Approved or appointed?
I was
appointed. So and so it by appointed is sweeper and the list. Yes.
The appointment of order is in page 22. Lordship, thereafter, one person, namely Kakuto, filed a writ petition challenging my appointment.
Tosile or Kakoda?
Lordship, this person has withdrawn midway. And during the pendency of that writ petition,
it was withdrawn.
What?
It was withdrawn.
No, the first petitioner who filed the writ petition challenging my appointment has withdrawn. Now, during the pendency of that writ petition, the present private respondent also has filed a writ petition 1176.
176, yes.
On the same ground that I'm not qualified to be called an indigenous person in terms of my.
No issue. Then.
Lordship, and then during the same writ petition, during the pendency of the same writ petition, my indigenous and ST certificate has been cancelled. When the matter was sub judice before this honorable court, my ST and indigenous have been cancelled. Page 26, annexure 6.
ST also cancelled.
ST has also been cancelled.
Page. When the matter was pending, then
the ADC, without without,
She cannot prove herself a scheduled tribe and
without informing me, has
Scheduled
cancelled this. My certificates.
This has been interfered with by the court.
Lordship,
Said,
challenging this impugn order, I have filed a writ petition numbering 194 of 194 of 20. Lordship.
yes.
Now these two matters, 176 and 190 have been brought together. And by common judgment in order dated 4/3/2022, Lordship will find this in page 27 of minutes. Married the operative part, the relevant portion, Lordship. Starting from para 23, which is on page 57 or 51. Lordship.
50?
On page 51. Lordship.
Yes, in the live discussion, Mariner, huh? Yes.
23 onwards. Married. Lordship. In the light of the discussion made about the court is of the considered view that the letter dated 15/11/2019, Annexure 8 to the notice dated 22/11/2019, and the letter dated 7/12/2019, and the order dated 10/12/2019, and the review in the present petition are all liable to the question set aside. The WPC 176/2019 is accordingly dismissed. WPC 194 is allowed. 25. The additional Deputy Commissioner Pugoboto, Nagaland is directed to allow Srimati Kutolisheki, the respondent number 4 in writ petition number 176/2019 to join her service as a sweeper under the establishment of the additional Deputy Commissioner Office Pugoboto forthwith in terms of the order number so and so dated 1/8/2019 issued by the additional Deputy Commissioner Pugoboto. 26. Considering the important issue raised in the present petition as to whether the petitioner is an indigenous inhabitant of the state of Nagaland and also a scheduled tribe of the state, this court deems it proper to direct the additional DC Pugoboto to inquire and verify as to whether Srimati Kutolisheki, daughter of late Inaka Sheki, qualifies the condition to be an indigenous inhabitant of the state of Nagaland as spelled out in notification number so and so, dated 28/4/1977, issued by the government of Nagaland Department of Personal and Administrative Reforms, and also as a scheduled tribe of the state. In doing so, all reasonable opportunity shall be afforded to the petitioner and all stakeholders. The additional Deputy Commissioner Pugoboto shall also summon and examine village authorities, elders of Lazami village, Mishlini village, and Pugoboto town to authenticate as to whether Srimati Kutolisheki is an indigenous inhabitant of Pugoboto, Nagaland. All the statement of the village authorities, elders shall be recorded in writing. The additional Deputy Commissioner Pugoboto shall be at liberty to take recourse to all reasonable measures as may be deemed necessary in the conduct of the inquiry. On completion of the exercise, the additional Deputy Commissioner Pugoboto shall forward his findings along with all the records.
Yes. It's your cancellation of ST as well as indigenous inhabitant certificate has been set aside. The direction was to make an inquiry by providing all the your opportunity and all, right?
Lordship.
See, Mr. MT, so far as the cancellation of the ST is concerned, you have to follow the mandate of the judgment of the decision of the Supreme Court in Madhuri Patil's case. Of course, what had happened, it says, impugn order says now that she is not qualified to be indigenous inhabitants. What about the ST? ST remains.
Yes, sir.
ST remains.
No. Unless if the indigenous cancel, then SCs are out of place.
No, you cannot. You cannot, by this inquiry, you cannot, because that will be in the teeth of the observation of the Supreme Court. Madhuri Patil's case. That's my this thing. iPad.
Here, the practice is, first, one should be indigenous inhabitant of the state. And that inhabitant.
Why you have only cancelled the indigenous? There's two certificates. One is indigenous inhabitant certificate, one is ST.
Yes.
Right?
So, yes.
You have earlier you have cancelled both. Now, by this present impugn order, you have only said that she is not qualified to be this thing.
I can it.
Huh?
So.
No, qualified to indigenous inhabitants, right?
Yes. So-
Consequently, indigenous inhabitants registers and so issued by the state cancelled. What about ST? You have not said anything about ST.
Your Lordship, the thing is, without indigenous ST is not possible to do.
It is deemed this thing
Yes,
cancelled.
indigenous, one applicant should be indigenous.
See, for example, I am a ST of the particular state, or I'm here. I'm somehow settled here. Take the analogy of me. I'm the ST of Arunachal Pradesh, right? I'm here settled for some time. But then I cannot be treated as an indigenous inhabitants. Although I'm settled, I'm a ST. Because ST is, you cannot change, cancel the ST as like this. Is not it? Therefore, she may be a ST, but then she may not be an indigenous inhabitant, but she may be a ST also.
No, it cannot. Because here, you see.
Then why you have no, see, earlier you have cancelled her ST also. There are two certificates. One is indigenous inhabitants.
One is ST.
ST. You have cancelled two, right? You have cancelled both the certificates. Then they have challenged it. Court has interfered, set aside both that cancellation. Directed it to make an inquiry, including not only the indigenous, including the ST status.
There is a self-learning here. Your Lordship,
No, I'm talking about the direction of the court. So once you have found that she is not indigenous inhabitants, why you have not cancelled the ST also?
No, Your Lordship, once the particular applicant.
I understand.
No, whose indigenous is cancelled, automatically it goes.
No.
It will go like that.
Earlier you have to issue two certificates, ST and the indigenous.
Yes.
You have cancelled both.
Yes.
Now by this impugn order, you have cancelled only the indigenous.
Means indigenous is the crux. That's the condition.
Nah. Then why you have cancelled earlier when the court has said, set aside, interfered with?
So that the installation of the whether is ST or indigenous, the property.
Earlier it was two ST, both the certificates were cancelled. Then she approached this court and court interfered, set aside both the cancellation orders.
Well, Your Lordship, I stated as a break. I'm quite willing to this matter, so I can receive your last part of it.
No. It's not a question of
No, I should be, intake with the subject matter. But since I have.
See, it's very clear. As per the records, it's very clear. Earlier, you have cancelled both the ST certificate and the indigenous certificate, right? Then she approached this court. Court has set aside both the cancellations. Cancellation orders of both the ST and the indigenous certificate. And directed to verify or make an inquiry in respect of both the indigenous as well as ST status. An indigenous inhabitant state and also a scheduled tribe of the state. This court deems it appropriate direct to verify as to whether so-and-so qualified condition to be indigenous inhabitant state as is spelled out in the suit by the so-and-so, and also a scheduled tribe of the state. Clear? You have verified as to whether she is an indigenous inhabitant, but as to whether she is an ST or not, that you have not done. So then in that case, she is ST, still ST.
No, he cannot be Bashik.
Then
You see, that is a.
you read para 26 clearly. Well, here you read the para 26. Para 26 of page 52. Page 52 of the writ petition.
296.
Page 52 of the writ petition.
Petition 197.
No, 293. 296. And, Nima Gopal, you just saw it, page 52, para 26 of the judgment. Take your seat, Aram say, and read that. What is the direction of this court? Please read para 26. You please take your seat and read it. In the meantime, I'll continue hearing it.
Hello, may I continue?
Yes.
Para 26?
No, I've read it. There was a direction to verify,
Yes.
inquire and verify as to whether you are indigenous inhabitants as well as ST, scheduled tribe. There was a direction. Then thereafter, what happened?
Page 53, Lordship, there is another very important point which I'm
What said?
relying on. Lordship, here, while taking the decision, may I continue reading from where I stopped, Lordship? Lordship, page 53, second line. On completion of the exercise, the additional deputy commissioner shall forward his findings along with records of the inquiry to the government of Nagaland, personal and administrative reforms, and or appropriate authority for the decision in terms of memorandum dated 1979 and in accordance with law. This next is very important, Lordship. While taking the decision, the government shall also take into consideration the judgment and order dated 13/5/1999, passed by the Honorable Division Bench of the Gauhati High Court in the case of State of Nagaland versus Ms. Nila Shokhe, reported in 1998 2 GLT 112. All such exercises and decisions on the matter shall be completed by the respondent authorities within a period of 6 months from the date of receipt of the copy of this judgment in order. The action taken by the government consequently to the direction passed by the court shall immediately be intimated to the petitioner and all the stakeholders. Now, Lordship, this division bench judgment, apart from the notification of 1977, where 3 criteria has been laid down. Even if, Lordship, this honorable court has ruled that even if I don't satisfy the requirements under 1977 notification, if I still qualifies the principles and the conditions laid down in Nila Tua's case, then I can be qualified as an indigenous inhabitant of this of the district, indigenous inhabitant of the state of Nagaland. Lordship, kindly see the judgment of division bench. Page 59, Lordship.
Is not reported.
Lordship, this is an extract of Manipatra. However, it is reported in GLP as well, Lordship.
This statement is reported in 1998 which GLP.
It's the one I annexed.
You just get the printout. Yes.
Lordship,
Page 59.
Page 59, Lordship.
Yes. Mr. Sharma.
Mr. Sharma, then it comes to for the respondent referring to the customary laws and practice of the Angami Nagas of Nagaland as prepared under the auspices of Law Research Institute Eastern Region of the court submitted that the adoption is recognized institution among the Angamis and is frequent in practice. It is not a case where the respondent were adopted for the purpose of seeking admission to medical course as already noted above. It was her father who was adopted by late Catholic of Kohima village as in the year 1962. He became a member of Kohima village. His name was changed to Kazupyo Angami, and since then he is living as an Angami Naga, having completely severed his ties with his family and his origin in Kashmir, and became the son of the adopted Catholic. He served as a teacher in government higher secondary school, high school. He was also the general secretary of the Naga Hills Tunsang area. He was married to Naga lady, Miss the petitioner. The petitioner respondent's mother of Elkel, and 9 children were born. Out of her brothers, one of her brother was allotted a seat to undergo BSc agricultural course from the Nagaland quota as a bona fide local, and after successful completion of the course, he's in Nagaland State Government Service. Her other brothers are receiving government scholarships for prosecution of higher studies. Pursuing of higher studies. As already noted above, the petitioner respondents completed her PV course from Kohima Science College, securing first division and placed in 3rd position in order of merit. She applied for being nominated to professional course in medicine. Her first preference is MBBS, second being nominated to professional course in medicine. Sorry, but my apologies, Lordship. I missed one there. Examination under this is
It was decided on their own packs. What's the issue here?
Pardon me.
Why you are referring this?
Lordship, in this very case also,
Huh?
although she was not qualified in terms of 1977, her father has resided in Nagaland during 1950s.
See, this was a case of adoption.
Lordship,
It's a case of adoption.
So I was adopted in Sunni customary practice, Lordship. I was adopted. I have been using the surname of a Sunni tribe without any objection all these years. I was born and brought up in the district of Sonibadu. There was no objection whatsoever. I have severe ties. My father has already severe ties with his family and relatives.
Where's the adoption? Any adoption?
Lordship, although there is no document to show, I have stated categorically. Lordship, these are customary adoptions.
Not the case when the respondent adopted for purpose of saying this court submitted adoption is recognized as so and so. Sumi tribe also is recognized.
Yes.
It was her father who was adopted to the Kohima village as back as in the year 1962. This is finding where it is.
The issue is totally different with the case involved in this case. If you see para 5, in touch judgment. In this case, in this 1998 case, there is no dispute about the indigenous Indian status. For selection for admission in this course.
Rule 5 of rules and
she was placed under category B.
placement.
So she filed against the petition claiming for her placement under
Cabinet is not allotting MBBS to children of non-Naga brother and also praying for fixation of indigenous category. Yes, interest testing. Hmm.
Married to me.
Hmm. Yes.
Also, so I'm here before this honorable court on a very limited grounds. Firstly, that the judgment of Minat law was not taken into account. Secondly, there is a gross violation of principles of natural justice while conducting the inquiry. Initially, Lordship, a meeting notice has been issued. Lordship will find this in the next 12, page 64.
I'm not convinced that this is a similar, this is not required to be taken up.
Lordship, whether she qualifies.
What is the law laid down here? It was on the facts only. What is the law laid down here?
Lordship,
So was the any law laid down?
it was clearly provided before the single bench and before the division bench. These are the submissions and the ratio comes.
Where's the ratio? What is the law laid down here? See, now it cannot by any wastage of emergency be said that way back in 19, her father was adopted solely with a view to have pave way the red producers admission to MBBS course. She has born and brought up as Naga child and going through the chapter on adoption as contained so and so, there remains deep doubt that she falls in Group A and Rule 5.2 of the rules. She is therefore entitled for consideration of her case as local candidate belonging to Group A for being nominated to the professional course, namely MBBS. Her petition prayer deserved to be allowed. It is on its own facts, it said. She was adopted in 1962.
This is on
born and brought up as the outer, what is it called? Angami tribe.
If we see paragraph 4 in the judgment, you should found the paragraph 4 of the facts reported to you. You see, the petitioner theory, she qualifies to be an indigenous native as per 1977. Since her father was settled by 1956. See, if we see paragraph 4 in the judgment.
You said apart from the requirement on this thing, notification 1977, law has been laid down here. What do you say?
1977 procedure is not administered.
This judgment was passed way after 1977. This is a 1988 judgment.
Sir, you say that apart from 77 requirements,
Yes.
this court has passed some guidelines or some additional law has been laid down.
I must admit that this judgment did not make any difference to 1977. However, the petitioner here also, they are placed in a similarly situated position.
See, this was recorded, it was on records that she was adopted. I don't know where you show us where it is your adoption. Have you said so?
Yes.
In your before the authority? Before the authority, where is your application? Seeking not to recommend indigenous, who is this? As she does not qualify to be indigenous. Where is your application? Have you filed any application?
What is the application regarding?
Request to furnish the remaining spread document in respect to inquiry conduct. It is.
There are 7 also stated.
Have you filed any application before the authority?
Before the authority, I have not filed any.
No.
You have filed.
That's good. You should become the page 67.
67.
67. This is a resolution submitted by the petitioner to the inquiry person. This was submitted on 27/7/2022. Should become the relevant paragraphs, para 3, and the prayer portion. You see para 3, which is 3. The inquiry meeting conducted also is at the office of the additional deputy engineer by notice status first. The final direction which had been verbally communicated to the other side, that is the petitioner, was to submit key documents which would fulfill the criteria prescribed in the clear resolution number 28 for the list for the final determination of her indigenous status. Nevertheless, it may be mentioned that besides such a PAR notification that Honorable Gauhati High Court has given direction to take into consideration of the case of the state of Nagaland versus Niloto Sukri, reported in Swiss. As such, stringently relying upon the state notification dated 24/1977, asking to understand submit the documents solely in that relation for determining indigenous status will prejudice the case of the other side. That also, and if you see the page number 73, that is the prayer portion. Here she has admitted that she cannot produce the documents as prescribed in the manuscript. Level 9, sitting the level 9. In the earth. Thus being aware of the fact.
No, it's okay. Notwithstanding the criteria prescribed in the said notification, the petitioner in the said case was considered as a local area, which in other words means that she was considered as an indigenous, even though no such documents prescribed in notification were produced or examined. Huh?
In the last paragraph, she has admitted that page number 73.
What is it said?
In conclusion,
Although the father had arrived in Nagal, particularly in the Pugeto area in 1996, he was unable to enroll himself in the electoral role as prescribed in notification due to lack of awareness. The absence of document to prove paying of house tax prior to this is because he did not own a house during that time and only rented a house which he could afford during that time. As for the third criteria for notification, the father of the undersigned could not afford any property which he could own due to financial technical assets. No fakta could be made. Assets being financial handicap, lack of awareness should not be made as to so. Thus, being aware of the fact that the undersigned has no documents to fulfill the criteria prescribed in the notification so has passed the judgment and under considering case of state or so and so. Other aspects were taken into account for determining the indigenous status of instead of notification. And as such, it is understood place before to consider the case of Eastern or so and so while they conducting inquiry for case and not to rely only on the availability of the When have you said anywhere that you have been adopted
No, that's it.
in this application?
That's it. That fits us. It's aim of my petition.
No, here in this your request to take into consideration. The undersigned prays for the special conduct of inquiry that in respect to writ Prince so and so to Prosecutor had also raised another request to the genuineness of responding may be made that the government the business had relied on the department so and so which has laid down the criteria for determining status of land. According the arguments were advanced by body plans during the hearing of the state. High Court by judgment directed the state to conduct inquiry and while doing so directed the matters will. Have you said that you have been
There are two of the same objections.
for the purpose of the one creator the name of the person of the various name on the should have been enrolled in the same way. That the name of the person and the devoted one, which is featured in the understand mother namely Amisha and by virtue of being the daughter of Lex, the family is entitled to according to him. Where do you have said that you have been adopted? Where you have said that you have been adopted?
By virtue of
By virtue of Srimati Anna. Your mother was a Sema, therefore you wanted.
initially, she was adopted by the father-in-law. Initially,
Who is your mother? Who is your mother?
I'm Muslim. So
He's a Sumi.
she's a Sunni.
She's a Sumi.
She's a Sunni.
Sumi tribe.
Sunni.
And who is your father?
Father is late Inakar, who is also known as Kumar.
Oh, he's not Sumi.
He's not Sunni.
See,
However,
therefore I'm saying in the Nakelu's case, what is good? Nakelu? Nilatu's case, it's a case of adoption. Way back in 1962, it was adopted, and as per the Angami customary law, the adoption is recognized. So she's indigenous. What's it? Your case is that your mother is a Sumi tribe,
yes,
father is a non-tribal.
yes.
Therefore, by virtue of your mother, there's no question of adoption. So what does it fit in?
No, he was adopted twice, and
When?
No,
You're making in the writ petition will not do. So what's it? You have not said anything here.
no, as far
See,
as
this application is filed by you on before the additional deputy commissioner, right? And then you file a writ petition
yes.
saying that I was adopted. That will not be sufficient. You could have given here or any, semblance of documents to show that you were adopted. Yes.
When the inquiry was conducted, since there was violation of principles of natural justice, I have filed these two documents as an objection to the inquiry being conducted by the competent authority. Lordship, this is only a part of
show us any documents that where you have said that you were adopted.
Lordship, for that, in order to determine whether I can be regarding my adoption and whether I can be qualified in terms of Nilatu's case or not. The
Nilatu's case will come when you were adopted. As of now, I have not seen any. You have not shown any documents that you have been adopted.
I admit, Lordship. There is no document, Lordship. But the village elders and the village council will prove that before the inquiry committee. Lordship.
Where it is.
Lordship.
Where it is proved that you are adopted.
Lordship, the country.
Lordship, otherwise there is one office memorandum regarding the adoption.
Yes, you said. See, there are so many judgments of the Supreme Court, as well as the High Court. It's not just because the father is a non-tribal. You cannot be treated as a tribal if the mother is a tribal. A child born out of a non-tribal father and tribal mother. There's lots of judgment, series of judgments. It depends. Normally the state like Nagaland and Arunachal Pradesh, they say that once the father is a non-tribal, you have no right to be given the ST or whatever, tribal certificate, tribal status, even if your mother is a tribal. But there is judgment of the Supreme Court. It's not on that. There's a like assimilation.
Lordship.
Though the father is a non-tribal, mother is tribal, the society, in the community, born and brought up, and all this thing, and the community has to accept you. If you have assimilated as born and brought up as a tribal in the community, see, all he can be treated as a tribe, can be a tribal. That is one thing you may have. But here you have not said anything. Nicholas, what is it? Nilatos case.
Yes, Lordship.
Nilato Sokri's case is a clear case of adoption in 1962, right?
Yes.
And all along he was brought up as a tribal, and everything benefits was given. In that context, only the preference for MBBS quota of that person was held to be, saying that the adoption could not have been only to obtain a MBBS quota, because adoption was done way back in 1962, right? You being you being born out from tribal and a non-tribal father and a tribal mother, if you can prove before the committee or the scrutiny committee that I've been born and brought up in the tribal community and accepted by the tribal, that means you have assimilated.
Yes, that's it.
Or else you have been adopted. In that context only you will be able to establish your value. As of today, you are not able to establish. Therefore, there is a reason why the Supreme Court has passed and issued a guidelines in Madhuri Patil's case, way back in 1994. Right? So I think with due regard that this earlier the coordinate bench has not been the case of Madhuri Patil's was not brought before the court.
I'm not aware of that.
It's a very this thing.
I have Anjan Kumar for him.
This is thereafter. Anjan Kumar, this has been thereafter, see so many cases. Anjan Kumar has been brought it back. That has also been diluted. The latest Anjan Kumar is 2000.
2016.
2012 also there is. Referring to all this. Anjan Kumar, no, you cannot establish before this court.
No.
If you say that you have been adopted also, we will not be able to pass any order because of the mandate of the Madhuri Patil's case. It has to be by the scrutiny committee, caste scrutiny committee. Then
And therefore, my prayer is limited. Although there is no document.
let there be a proper scrutiny.
Yes, Lordship. Because, Lordship, the one counsel who was also representing the respondent before this honorable court, he was allowed to be present before the inquiry committee, whereas on my side,
I'm going to all this.
no counsel was allowed. No, Lordship. And I have some judgments in that regard also, Lordship. Lordship knows that when one party is represented by legal counsel, the other party is also entitled for that same equal right, Lordship.
Yes. Yes, continue.
Lordship. Lordship, my ground is that although there is no written document, the village authorities will prove whether I have been verbally in customary style. I've been adopted by Sri Ashina, firstly by Shihani, and then later on by Ashina Sheki or not, because I've been using this surname all my life. I was born and brought up in this district, and there is no objection as to as to usage of my surname also, Lordship. So in this case, Lordship, she has been assimilated to the community without any objection, Lordship.
You are not able to show anything. Where is any documents?
Lordship, since there is no document, the village elders and those who can depose on in my favor, they'll present before the inquiry committee and they'll depose before the inquiry committee in my favor, Lordship.
Where it?
Lordship, they have not been called for. They have not been called for, Lordship. When the meeting was called,
Very strange.
I was the only person who was called for the meeting, and I was not asked to bring any documents also, Lordship. Lordship, we kindly see the meeting minute. Sorry, the calling of the meeting.
Coordinate. It is very poor. Lordship. Code number why is the only code number 2 is showing?
Lordship, I'm allowed to give my submission.
Just wait, he has not completed.
Lordship, therefore, my prayer is limited, as I've stated, Lordship. There is a gross violation of principles of natural justice. One engineer Kishato, who was never a party, who is a stranger to this matter, was also made to depose, and he was called for a meeting, and he was made to depose in favor of the other party, whereas on my side, nobody has been called for to depose.
See, yours,
Lordship.
where is the inquiry? Verification, inquiry report?
Lordship, the inquiry report is in page 77, annexure 18.
77.
Lordship. And may I show your Lordship, in page 78, the statements.
The meeting is also ensured council member governors to verify the it was they said in the meeting that they would verify in the village council chairman. You are from which village?
I'm from initially my father resided at Lazami village. And therefore Lazami village council has given this statement, Lordship, before the inquiry committee.
A meeting was held on Sunday with the council members and governors to verify. It was decided in the meeting that they would just certify the indigenous service since the parents had settled in the village prior to 1962, and the verification report the same was submitted to the officer. This is Lazami village.
Lordship.
Then,
and as far as adoption is concerned, individual persons will prove this, Lordship. But no individual persons were going to support were invited to support the Lordship. And then at number 4, Lordship. Please already this Chairman Lazami. Right. He stated that he had appended his signature to the copy of citizenship of Mrs. Anil family, mother of Putul Sheki, without being told properly of the purpose of the said document. He came to know the indigenous issue only at a later period. He also learned that late Imam family had come to Gauhati in 1974. Hence, he submitted his withdrawal on investigation of the citizenship issued on 21/10/2019 and declared that the document null and void. A report which was submitted to the Office of Deputy Commissioner on 23/3/2022. Lordship, so this person has issued a document in favor of the petitioners, stating that petitioner's father had come to.
But it was recorded, it was recalled.
It has been withdrawn. However, whether he on individual capacity has withdrawn this document or not, Lordship, that has to be taken into account. Lordship, may kindly see next page also, next page. This is it. And we have to principles of legal justice again at number 6, Lordship. Engineers.
To whom it might concern, whether he had recorded the late Kumar had come to Kohima as a carpenter. His presence in the promoter yes.
This person, he's a stranger to the present case. He is not either from either a petitioner or the respondent.
Representative, who is your representative? Who is the petitioner? Yes. Here, in this proceeding, they said petition submitted a representative petitioner. Tushila. Respondent submitted a written statement. You have also submitted a written statement.
Yes.
Then, where is your written statement? Any of the documents as prescribed in notification to which the respondent pleaded for more time to collect, hence the official decision 14 days time. Yes. Thereafter, you have not submitted.
With regard to 1977, I did not submit any documents of being in that regard.
Do we have the scrutiny committee in the state? That's the scrutiny committee.
Recently, the Drain Commission has been constituted. Otherwise, earlier it was no such. My lordship here, I think the Lord will give a submission, but
I'm just asking, let me know. Yes.
Therefore,
Where is your written statement? Why you will not annex it?
as far as written statement is not concerned, to me, I will allow to see this instruction in the.
No. Why you have not annexed here? You have filed a written statement. Yes, continue.
As far as the question is concerned, I have to say.
No, we're disposing the matter today.
Because Lordship, I was correctly instructed that there was no written statement.
Yes.
Lordship, if at all there is a written statement, then this was not provided to me, and I was incorrectly instructed that there was no written statement. As far as written statement was produced on the day of the inquiry, Lordship. Lordship, my prayer is that proper verification may be conducted, since proper verification has not been done before the competent
See,
authority,
this
Lordship.
Nilatu's case, basically a case
Lordship.
whether the preference given to the local indigenous in the MBBS course
Lordship.
it be permissible under the law. Supreme Court has is permissible. I mean, the division is permissible. Therefore, on the facts of that case, finding the respondent to be adopted in 1962, it was allowed.
Lordship,
To be entitled to have that preference.
I respectfully
So
submit.
basically, the issue was whether the preference to the local indigenous inhabitants or the local tribal in the MBBS course is permissible under the law. This law was there. I mean, the issue was there.
Yes.
Question of law.
And
It was held to be permissible in view of the judgment of the Supreme Court. And in the contextual facts of that case, when the respondent or whoever was found to be adopted in 1962, which is recognized as in the customary, as per the Angami customary law. Therefore, and she was born and brought up, everything was there accepted. Therefore, she was entitled. He was entitled to have that kind of thing, quota, as a tribal. That is the case. Your case is basically, I don't know how you are projecting it, as per your own documents.
Yes.
Your father has settled here before 1962 or maybe around 1962. And mother is Sumi tribe.
Yes.
Therefore, you have been born and brought up as a tribal, as a Sumi tribe. Therefore, you are entitled to be. Because that you may have a point on that. But in this case, you have not projected so far.
Also, my case is the father has settled around 1950s and 1960s.
So
He has married one lady, and the father of that, the father of his wife has adopted her initially.
Father of his wife?
Yes.
Whose father?
The wife's father.
Wife's of.
I have categorically stated in my petition also. And then after the first wife has passed away, she married Anes and the present petitioner's mother. And then later on they moved to Bogoboto town. And then one sweet Ashinas Sheki has adopted the family again. Now,
How can the family be adopted?
yes.
How can the family be adopted? Under what law?
The father, sorry.
Huh?
The father was adopted again. Now the lady.
Who has adopted? Father? How can the father be adopted? Under which law?
Lordship, that is under customary practice.
Who has
And therefore,
Adopted the father or adopted the daughter?
Adopted the father, and therefore,
How? What is the
But
practice here?
this customary practice, the elders will be able to prove before the inquiry committee. They will be able to prove, Lordship.
It will be a very strange kind of
I'm
thing.
just praying for an opportunity.
Can I be adopted? Can I be adopted now? If you wish to give myself for adoption, can I be adopted?
Lordship, I'm not a customary expert yet.
Then why, if you are not expert and if you don't know, then what is it? You may not be expert, but then why you have to say that it is customary, it is permissible? You must have something to say.
I'm only praying for an opportunity to.
No, it's okay. Opportunity you have been given. You have not projected your case before the authority earlier, which you had an right. I mean, you have an opportunity.
Lordship, I was not given the opportunity.
See, you are saying you. What do you mean by you are saying that since your father was adopted by Seki,
Lordship.
so I automatically became this thing, tribal. Suppose I'm adopted,
Lordship.
my son will be automatically be a tribal.
Lordship, in terms of-
How can your father was adopted?
And therefore,
What is
Lordship,
the law of adoption? Forget about the customary. What is the law of adoption? If you are saying that your father was adopted,
Yes.
you are not saying that you were adopted. You are saying that your father were adopted.
Lordship.
Huh?
Lordship.
How?
Lordship, of course, as explained, one has to be minor, but whether that is allowable in customary law or not, this elders who are conversant with customary law will prove that. Lordship.
You will dilute the law of adoption. I was wondering. Your case lies somewhere else. And you are projecting the case in a different way, which is very difficult to accept. Simply saying that you have not been given an opportunity will not do. First, the foundation has to be established, isn't it?
Yes, Lordship.
Thereafter, saying that I was not been provided with opportunity is not. One more thing, what is the requirement to be indigenous? Let us see that requirement.
Okay, we'll find the notification, the page 23, initial form.
Government to propose employment. For the purpose of employment, as envisaged in the ordinances, a person should have settled primarily in Nagaland prior to 1/12/1963. The following shall be the criteria for determining person to have had a permanent employment in the service. His or name or parents were less than guardians in the case the person was not minor. Should have been entered in the electoral roll. His or her name or name of parents or legitimate guardians. In case the person was then a minor, should have been entered in the electoral roll published on so and so. Your parents ought to have been in the electoral roll, right? Then the person or his or parents or legitimate guardians should have been paying house tax. The person or his parents or legitimate guardians should have been acquired property and patta or in patronage. It has been further said only those certificates issued by Deputy Commissioner and additional bills shall be accepted with immediate effect from this so and so as the next thing. Yes, you don't fulfill any one of this. Any one of these three. You don't fulfill.
Man wants to take your notes to the inquiry report.
You are not challenging this.
I'm not challenging that either, Lordship. Lordship, this is relevant.
Sir, you are in a very sticky wicket. Difficult. Yes.
Lordship, I take your to page 76. Page 77.
Yes.
The inquiry report. Lordship, in the entire inquiry report, There is no statement, no reflection of that the earlier division bench judgment, which in the earlier round of litigation, the court has directed to take them into account, to take them into consideration. However, no utterance has been made in that regard, Lordship. And therefore, that is a violation of the binding direction given by this honorable court. Earlier judgment.
Saying what?
Saying that because of repetition, may I read that 11 portion again, Lordship. At page 53 in the earlier judgment, while taking the decision of the government shall also take into consideration the judgment order dated 13/5/1998 passed by this honorable division bench of Gauhati High Court in the case of state of Nagaland versus.
I'm not impressed.
Lordship, in this case also, the very issue that has to be determined is whether this person is a person that can be considered to be hailing from the state of Nagaland or not. That is the same as indigenous, Lordship.
Yes.
Now the inquiry is silent about whether consideration has been made against this judgment as directed by the civil bench, Lordship, in the earlier round of the litigation, Lordship.
Judgment is not relevant.
Whether the judgment is relevant or not, my respectful submission is the witnesses will come and prove that before the inquiry committee. This opportunity was not given to the present petitioner's party, Lordship. Except that she was asked to prove whether she qualifies the conditions of notification of 1977 or not, whether she qualifies in terms of the division bench ruling or not, that opportunity was not given to her, Lordship. So I'm
See, your case is lies somewhere and you have trying to. Nineteen ninety four. 1994, 6 SCC 241. Kumari Madhuri Patil versus Additional Commissioner. Get that sentence. Have you not come across this case?
no.
Caste certificate, citizenship certificate. This is the law way back in 1990, first in 1994. How to go in, Supreme Court has given, is still in vogue. There has been in long line of cases that has been allowed. Yes.
That's all for my case on this one.
Huh?
That's all for my submission on this one. Also, requesting clarification from my side. That there's a gross violation.
1998, Nilo, what? Nila? Nika? Nilatio's case is not relevant.
My witnesses will prove that. That is my submission. And also, Lordship, there was no legal persons were allowed to be represented by the other party. However, I was not allowed the same opportunity.
I'm trying to tell you, this is not your case, is lies somewhere else. You are not placing the relevant laws.
And I may be permitted to give, to get instruction regarding the written statement as your lordship has been asking.
Yes. See, so far as the ST issuance of caste certificate, including travel certificate. Way back in 1994, Supreme Court has issued a direction to all the state government to constitute a caste scrutiny committee. Whether you have that or not, it's the state of Nagaland. Do you have that?
So far, we don't have, but recently we have considered one green committee, that is a registered indigenous inhabitant.
Huh?
One committee is already constituted.
Hmm.
So as per the committee, we have to pay some all those 1977 certification and OIM 2008, 2012, referring to all those things. So in the present case, Your Worship, how that indigenous, the difference of the indigenous and social tribe certificate, that is also covered by the OIM 2008. And again, adopted son. That as stated by Your Worship, the father is non-local, mother is local. So that regarding those adopted son children are not allowed to issue indigenous nor the SC certificate. That's also covered by the Office Memorandum 2012. So in this connection, I will allow to file an additional affidavit.
No, you just give them. We have enough time, we are spending and what enough, why should it?
So then, if it is not allowed, please we will place on record the motion.
Authority to issue scheduled tribe and indigenous inhabitants. In preparation of the authorities, scheduled tribe indigenous report the principles within their speaker. But it has been brought to notice that still many ineligible applicants have been able to obtain ST without proper verification. Only issuing authorities have meticulously verified government. For issuing the preparing of the cell response. Personal is responsible for literally in the problem website. It has been observed that certain agencies are issuing scheduled tribe, indigenous and backward tribes and without proper scheduled tribes are safety, verified. It was claimed before says and also see that symbol of one claim before the meticulous verify the genuineness of the claim before issue. Such certificate and also change this. Children of non-Naga father,
Yes,
as well as non-Naga children adopted by Naga parents.
yes.
By this notification, even assuming that you are adopted, this which says non-Naga children adopted by Naga parents are not to be given scheduled tribe, backward tribe, or indigenous. What is indigenous inhabitants and the scheduled tribe?
Indigenous is a primary documents. Why should be indigenous inhabitants? And now, as a indicated a range that the registered indigenous inhabitants, that the committee, they are enumerating who are the senior indigenous inhabitants are listed. More particularly.
I'm asking, what is the difference between indigenous inhabitants and the scheduled tribe? One can be scheduled tribe without being an indigenous inhabitant.
No, one should be indigenous. But in the state of Nagaland, we are also scheduled tribe.
Then when in 1977, why you have said that those who have settled in they should have their name listed in the electoral?
Because of 1977, the indigenous has come. And because of the Nagaland Act 1970. So because of which indigenous, the nomenclature indigenous inhabitant fusion analysis. Because unlike other state, Nagaland state formation of the. Nagaland
It's
state
okay.
formation-
I've understood. Why you are
Yes.
trying to understand what I'm trying to know? Whether the scheduled tribe certificate,
Yes.
if a person is a scheduled tribe, can he you need to have the indigenous certificate.
No, our case, so only those indigenous are allowed to obtain the social grant.
Where
So-
is
so
it? 77
indigenous-
says something different. 77 says something different. Page, what is that page? 23. Please to decide the order to qualify an indigenous inhabitant instead of the proposed employment. A person should have settled permanently in Nagaland prior to 1963.
Yes.
What's the question of settled tribe here?
Those university.
Don't go by your common sense. Let us go by this the documents.
University.
Please.
Why?
You read page 23.
I will be allowed to assist.
Ah.
Why 1 December 1963? Why? Because it is about the outsiders. It is about the outsiders.
Huh?
Outsiders. Outsiders, non-Naga, those who have resided prior to 1963,
Hmm.
then they will become indigenous.
Therefore, then outsider means what? They must be they not necessarily should be a tribal.
But those who
He
are,
may be non-tribal.
those outsiders, those who are resided prior to that, then they some will be situated, they will get situated something. And some are in.
How can be? How can that be? How can the non-tribal can be issued a settled tribe certificate?
32nd of the also, why suddenly doesn't.
See, to issue a cutoff, the scheduled tribe certificate, cutoff is not required.
Cut out this.
That's why I've said the indigenous, the earlier indigenous inhabitants, phraseology or the phrase indigenous inhabitant is nothing to do with the scheduled tribe status. Read page 23, please. I'm talking about, we're on Nagaland only. We're not talking, discussing about the Japan.
Yes.
We're discussing Nagaland only.
That time the reason 1977 is silent about the essential tribe. You mean that one. So it's silent about essential tribe, 1977 notification. So in that case, if at all those applicant or those citizens comes from the essential tribe, then will issue the essential tribe certificate. Otherwise,
No, sir, you are not clear about my query. What I'm saying is, in 1997 notification, you said to qualify as an indigenous inhabitants, right? For purpose of the employment, one should be settled permanently prior to 1/12/1963.
yes,
For that, there are three criteria.
yes,
One is parents has to have entered in the electoral roll, or should have been paying income tax, the house tax, or his parents or anything should have acquired property and patta prior to 1963. These are three conditions.
yes,
Suppose a non-tribal, like her father, suppose parents settle permanently before 1/12/1963, she will get the indigenous certificate, indigenous inhabitant certificate.
yes.
But fact remains that he or she is
inhabitant,
a non-tribal.
non-Naga.
So what's the question of to become a ST, you must be an indigenous inhabitant. And state had issued two certificates separately. One is indigenous certificate, other one is scheduled certificate. Your Advocate General is around. See, I'll tell you, it has an implication. You cannot take it lightly.
That's right.
It will have a bearing on the state.
This matter was.
It will have an effect bearing in the larger public.
Custody is.
So you clarify whether you're simply saying that one for ST, one must be indigenous. It doesn't support your notification. Indigenous, they have been inhabitants to become an indigenous inhabitants for the purpose of employment is something different. Do you have the writ petition? Do you have the writ petition, sir? I think you have not gone through. Were you busy yesterday?
No.
It's a very, very important. Maybe it's a matter of
Yes.
appointment, a post of grade 4, peon or chokidar. Sweeper, grade 4. But the issue, once we decide, it will have a bearing on the state
Definitely.
as a whole.
It
Why you are not taking it seriously?
Just taken over. And in order to clarify all those doubts, I'm allowed to file an additional
What
affidavit.
is this? What additional affidavit? Simple thing. Because you have not gone through the petition, that's the problem.
I have one, but it's not that I applied from the registry or my.
One is not that this is not important. Whatever this the writ petition were on, it will cover everything.
So.
It's not a labor. This will cover everything. I'm asking a very simple question.
Yes.
Is there any difference between Indian inhabitant certificate or ST certificate? Hopefully in the state of Nagaland, you don't have the scheduled caste.
No.
Only scheduled tribe.
Only scheduled tribe.
Then by looking at the notification of 1977, it indicates that you don't have to be a scheduled tribe. Only the criteria is that you have to permanently settle on or before 1st of December 1963.
So I will be allowed
No.
to explain.
All they were spending on this.
Motion.
Her rights at scheduled tribe and then indigenous in Nagaland hereby cancelled from this date itself. Where is your scheduled tribe certificate? And the scheduled caste? Indigenous certificate.
Which it is 61.
61.
That's the schedule certificate.
Birth certificate?
Birth certificate is in page.
Scheduled tribe is page 61.
Was it?
Junior.
Copy is in page 62. And then
This is certificate Sri Kutesuli Seki so and so and this thing in this term now belongs to the Nagasumi tribe, which is recognized scheduled tribe so and so so and so. Then indigenous certificate of indigenous.
Even indigenous certificate has been issued in favor of the.
This is Srimati Kone so and so, letter of Inaru Seki. Town so and so in Junabuto belongs to Nagasumi tribe, which is recognized as scheduled tribe under the constitution. And that's it. From the ordinary size in the in a village town in the sense.
Okay, we find that scheduled tribe as well as the non-indigenous certificate has been issued after the issuance of this notification, which the government has just produced. And in order to issue such certificate, once proper verification has And since the village council has there's no objection to that.
Will you try to find out what I have tried to indicate since morning? The judgment of the Kumari Madhuri Patil. You are supposed to have a scrutiny, caste scrutiny committee. The state should have the caste scrutiny committee. And it should be the admission wrongly gained or appointment wrongly obtained on the basis of false social status certificate necessarily has the effect of so and so. It is therefore necessary that certificate issued are scrutinized at the earliest and with utmost expedition and promptitude. For that purpose, it is necessary to streamline the procedure for issuance of social status, their scrutiny and their approval, which may be the following. All the state governments shall constitute a committee of 3 officers, namely an additional or joint secretary or any officer higher in rank for a director of department concerned, director of social welfare, as the case may be. In that case of scheduled caste, another officer so and so, so and so. You are bound to constitute a committee.
Other state, where there's a lake.
Earlier it was, by this judgment, is 3 members. It was sent to in 1996, 5 members. You are failing on your duty. It's been done. Is your advocacy around?
No, no.
Sir, it's not as simple as what we are trying to proceed. It's not that.
This impact will be, I mean, already cascading effect. And the thing is, if our handle from the very beginning, or can assess the court, another court.
We'll continue tomorrow. Continue tomorrow. You take up the number 1, whether you go through, both of you go through, all of you, Limafang also. You just give them the citation. The Madhuri Kumari, Madhuri Patils, there are 2 judgments. Initial 1994 judgment, 3 member. The state was supposed to constitute caste scrutiny committee. And thereafter, in the same, but this thing, I think somewhere in 1996, the member has been increased. Right? Same case. Then that's the only difference. Whether as per the Supreme Court judgment, whether you have a caste scrutiny committee or not. You obtain.
Okay, I'll obtain the instruction.
Today itself. Obtain an instruction as to whether you have state has constituted a caste or tribe scrutiny committee as per the mandate of this Supreme Court. Way back in 1990. You just read the para 13. Then what is the difference between scheduled tribe certificate and the indigenous inhabitant certificate? And what is the basis of issuance of indigenous inhabitant certificate? What the notification of 1977? Note it down. Or whether Advocate General can appear tomorrow.
I have to talk to him, whether he can appear to.
See, this will have an effect on your state, so far as travel is concerned. And apparently, prima facie, suppose you have not considered a scrutiny committee, you will have to do it. It's a mandate of the Supreme Court. Right? And when you have decided already by now that parents of what is called non-Naga father, the children of non-Naga father and non-Naga children adopted by Naga parents are not to be given children. This is also against the Supreme law laid down by the Supreme Court. You cannot. You'll have to, for that only, you have to have the committee to scrutinize. And that aspect is that the case of the Supreme Court has recognized the case of assimilation.
Yes.
Even if the children of non-tribal father, but tribal mother, normally in the state like state, the northeastern state, they oppose it. Right? But Supreme Court says no. If you can establish and it is accepted by community, my personal and your personal disliking will not do, or the state disliking. You have to go by the law. Is not it? So this is also against the established settled law. You cannot have this. And what's the meaning of adoption? When the adoption is recognized. Right. We'll continue tomorrow. With a hope and trust that you'll come up with, equip with all these weapons.
If it is not on theater tomorrow, possible.
Day after tomorrow, not possible. Day after tomorrow, not possible. Tomorrow we'll do it. After DP. And I have indicated you. You are not projecting, not you, I mean petitioner. You are not projecting your case the way you were supposed to. And you have not claimed the petitioner, maybe you are on the instruction of the petitioner, obviously. Petitioner is not claiming what the way she was supposed to. Simply saying that and all those things. It's not clear whether you are that will be very strange, even if it's recognized by the customary thing that the father is adopted. You're just diluting, and it will be in the teeth of the law of adoption. No, you are a lawyer. Number one, you said you are not the expert of the customary. You have to ask them. You are representing the petitioner. You are the mouthpiece of the petitioner, spokesperson. So you have to know. You may not be expert. As per the customary, the law as recognized by the Sumi tribe, Subi Naga tribe, these are the things which has been projected in 1998's case, Nilato's case. And number two, the adoption, even if they try to say so, it is done. You being a lawyer, you must know what is the law of adoption. I'm not saying that you don't know, but you know, but you don't want to speak. Because it will go against your the foundation of your case. But there is a way out. Fairly submitting that this is against the law. However, this is the thing. You have to move that way. Right? Do you agree? Father cannot be adopted. Is against the law of adoption.
Respectfully.
Then why not grandfather?
Was adopted by grandfather. Very good.
Sir, please. Only for you, I'm adjourning it. I've heard you. I don't think I should hear you also. Is that it? But definitely, I will give you a chance. But then I don't think it is necessary. Do I need to hear you? Heard, Mr. Learned counsel for the petitioner. No, we'll say. And then Mr. MT himself, London Additional Advocate General, as well as Mr. Lima Wafal, for respondent number 7. Respondent number 7 in item 296. Both this. Jesus, after hearing the matter at some length, I find that certain instruction which is crucial for determination of the present matter from the state authorities would be required. List of accordingly, matter be listed again tomorrow, so and so as to enable Mr. Im Chong, the Additional Advocate General, to obtain instruction, particularly as regards the constitution of Caste/Scrutiny Committee, the basis of issuance of indigenous inhabitant certificate, qua the notification of 1977, and the difference, the difference between the scheduled tribe certificates and indigenous inhabitant certificates. Matters remains part-heart. We'll keep it part-heart. Please don't make any excuse tomorrow. We have spent almost whole day.
Yes.
This is it.
What can we do?
Why you are additional advocate general? Don't you have any, authority?
This is where legal some instruction.
Just
Yes.
you'll get cut them.